All right, hello, government class. Hopefully, the quarantine isn't making you too stir crazy, that you're keeping up with all your schoolwork, doing all the things that you should be doing, helping out around the house. Um, I've decided that I might record a couple things throughout the next coming weeks as a means of being able to communicate to you what I'm hoping you get out of the readings and the court cases that I'm having you look into. All right, so obviously, we've been talking about the judicial branch, and of course, this week, we are primarily talking about due process. All right. And so when we start talking due process, we have two types of due process. We have procedural due process and substantive due process. So procedural due process is basically the procedures that government does, or the police or whomever, needs to be constitutional. All right. So for example, I think I gave you this example before we took off, but the case where the police come in and they try to arrest an individual for selling or possession of drugs, and the individual has the drugs on the nightstand and they eat them before the police can get them. And so they take the individual to the hospital, have the contents of his stomach pumped to get the evidence of drug use and possession, and then charge him based on that evidence. And of course, what the Supreme Court ruled was that the procedure there was unconstitutional. The idea that you would forcibly remove the contents of someone's stomach to get evidence is unconscionable, and that's not what the process should be. So that would be an example of procedural due process. All right, substantive due process is that the substance of the law has to be fair. All right, and so it's the law itself. It's how it's written, and we're going to look at a ton of examples of substantive due process. So one is that the procedure has to be constitutional, whereas the second, substantive, means that the substance, the meat of the law, has to be constitutional. And so that's when we start looking at Fourth Amendment cases in particular this week. That's kind of what we're looking at. All right, so the first thing we look at, of course, or I had you look into, was privacy rights in regards to due process. And in particular, the leading court case on privacy rights is Roe v. Wade, the abortion case of 1973. And of course, Roe and Wade are names that are aliases, if you will. They're protecting the individuals who were involved in this case. And so Roe v. Wade, of course, is the landmark case. It's been hotly debated, and of course, it's a very touchy subject for a lot of people because it's a very personal subject. And so hopefully in your comments and other things on the assignments, you take that into account. But when we start looking at the Roe v. Wade case, of course, basically what Roe v. Wade did is they took the issue of abortion as a state issue, where states usually were able to determine what their policy on abortion was going to be, and took that away from them and made it a federal decision. States have to allow abortions, and of course they laid out the parameters of when that was. And then, of course, subsequent court rulings have kind of redefined the abortion case, and so hopefully you're kind of reading through those and looking at that. And then, of course, I had a discussion question for this week because, again, there was an issue in regards to essential surgeries, that non-essential surgeries are not going to take place. But, of course, the governor was asked many, many times this past week as to whether or not, the legality of denying abortions because of this coronavirus. And it brings up a constitutional question. And again, I've asked you to give your input on that. And again, I hope you are thinking about that a little bit as to where do you fall on that issue, and what do you think? Because the two sides basically are that it is a time frame. All right, that Ohio has a time frame in place and as to when abortions can take place. If that procedure is going to be taken forward. And of course, this preventing of surgeries, non-essential surgeries, is definitely causing problems with that. All right. So some people view that as being, denying their constitutional right for this procedure. Others are looking at that it's not essential. It is an elective surgery. And therefore it shouldn't be going forward at this time. And so It's a very, again, sensitive issue, and it's a very personal issue for a lot of people. So, if we were in class and we could kind of hit some of these nuances, that would be nice. But just kind of keep that in mind as you're going through this and you're kind of looking at these issues. Obviously, many people feel very strongly on both sides, and so that's one of the beauties of course, our system. You can have those feelings and be respectful of both sides. So the right to privacy cases is kind of the first part. The second part then really kind of focuses on the Fourth Amendment's illegal search and seizures. What can the government do in regards to gaining evidence as a means of presenting a case? All right, we have protections against government abuse. That's what the Bill of Rights is all about. All right, and those protections are no illegal search and seizures, that the government has to present a case against you. It's not up to you to defend your innocence. It's up to them to prove your guilt. And so acquiring that evidence is really kind of the focal point of the whole Fourth Amendment cases. All right, so for example, the California versus Acevedo case that you have to look up is about automobiles and searches of automobiles. Can you have a warrantless search of an automobile because they could drive away and do something with the evidence? And initially, the answer was no. But after this case, the Supreme Court is going to say, well, yeah, cars are kind of mobile getaways, and therefore the time it would take to go get a warrant to search the car, the evidence could be gone. And so it kind of changed the procedure in which the police can operate in order to try to obtain evidence using automobiles. All right. And then, of course, just so I can make sure I get it right here, Katz versus the United States. In the Katz case, it's a wiretapping case. They're trying to prove that this individual was gambling. They tapped a public phone. Back in the day when people used payphones, this is, what they ended up tapping to get information so that when he went into the payphone and made his calls, they got him. And so they used that evidence, and of course he was like, well, that's an illegal search. You can't do that. I had the right to privacy. And the initial argument of the police, of course, was that you have no right to privacy out in public. But the court disagreed. They said when you go into a phone booth, you have an expectation of privacy. And they said that procedure was illegal in that situation. And so, that's where the court has to come down. Weighing the evidence and what is being presented versus our protections against government abuse. And so this is referred to as the exclusionary law. If any evidence is obtained illegally, it has to be thrown out. You can't just have the police or the government agents being able to take evidence any way that they wish. There is a procedure that needs to take place. And so in many cases, it's that question of, did that cross the line? Did that not cross the line? Should that evidence be thrown out, or should it be admitted? And of course, the arguments are that if you're excluding evidence, obvious evidence that's going to determine somebody's guilt, and you're throwing it out because of how it was taken in, you're obviously going to allow somebody who is guilty to walk free. All right, that they're going to go free because the evidence wasn't, obtained in a way that it should have been, when the evidence obviously points to guilt. The other side, of course, is that, no, that's exactly why we have it, that the police have to act accordingly. They have to follow the process. They can't just do what they want, when they want, in order to prove your guilt. That the process needs to be there as a protection for us against government abuse. And so it's weighing those two distinct situations of making sure that guilty individuals pay a price for violating law, while at the same time protecting individuals from the abuse of government and obtaining, illegal evidence. And so a number of the court cases that I'm having you read up on kind of address that situation. So, and it ranges from the 60s, where the exclusionary rule really kind of was much broader, that they were like throwing out a lot of things saying, nope, you got to do a better job, police, to more recent cases where they've kind of really shrunk it down, saying, there's a good faith clause here, that as long as the police are working within good faith and they're trying to do the best they can, all right, they may not have done everything by the book, but they did what they thought they should have done or how they should have done it, and so it's okay. And so that's where a lot of the later cases are, and that's where we're kind of at with the exclusionary rule right now. So those are some of the things that we're talking about or would be talking about if we were in class right now. Hopefully you're reading up on those cases. We'll have some quizzes later on over those. So in the meantime, until I guess my next video, I hope you guys are well, that you're healthy, and that, again, you're keeping up with your work.